Okay, council is ready. State of Iowa versus Colby Laub. Mr. Howe, are you ready?
Thank you. May it please the court, counsel. The implied consent regime is an important sword in Iowa's attempt to prevent and punish drunk driving in our state. But it is but one sword in that arsenal, and it is not a shield. The district court in this case erroneously suppressed evidence obtained pursuant to a warrant issued by a neutral, detached magistrate. In doing so, it reached a statutory interpretation that is at odds with our rules of statutory interpretation, found a conflict where none existed, and applied equal protection and due process in a way not contemplated by our courts and manifestly erroneous. I think this case breaks down under first principles and becomes quite clear. Implied consent is a long-standing constitutional exception to the warrant requirement, where it deems the drivers have impliedly consented to a withdrawal of a specimen and the chemical testing of that specimen in exchange for driving on our roadways. That consent is immaterial when the state goes to the trouble of obtaining a warrant to obtain the specimen and necessarily test it.
Then what good is that right if the state can just bypass it whenever it feels like it?
The difficulty is that we're in a brand new phase in our history in which roadside warrants or expedited warrants under electronic means are available under this court's pilot project. But what that doesn't mean is that a warrant exception ceases to be of value. In any other investigatory instance, if an officer, say, asked for consent to enter a home, the fact that a warrant requirement exists is not a problem. The exception is sufficient. So in this instance, let us say that Deputy McRae, in this instance, attempted to log into DocuSign and found that the server was down. Implied consent would still exist and would still be a viable means to detain Mr. Laub, obtain a specimen, and test it. These things can coexist, and we don't go looking for conflicts and to find specific over general where there's no need to. Here, we obtained a warrant, and the fact that another warrant exception continued to exist is immaterial. It doesn't write it out of existence, and it doesn't render it a nullity.
New. I mean, implied consent's been around a long time, and now to hear about warrants instead of, I'm just curious, is it?
New and not new, Your Honor. I'm a connoisseur of context, and so I like to talk about history, but the difficulty of obtaining a warrant historically when the implied consent regime was developed made it quite burdensome and often would times fall outside of the 2-hour window that the statute had anticipated. Later on in Hitchens, this court ruled that once an officer attempted to invoke implied consent, we could not, the state, then go and get a warrant independent of that sequence. Fair enough. So the legislature stepped in and amended 321 to say that in certain circumstances, even when the officer has invoked complied consent and the person has refused, we may still go get a warrant.
I mean, I think the defendant would say at least that sequence of events, Hitchens and then the legislative amendment, you can infer from that that maybe the legislature wanted police officers to ask because they wanted to reduce the risk of confrontation between the motorist and the police. And at least some other states have adopted that position. In particular, those states who have the no test shall be given language similar to the Iowa statute. So what's wrong with that reading of the history?
So I would submit a couple things in response to that. One is that let's look at our refusal statute just for a moment. And it says that if a person refuses to submit to the chemical testing, I would submit that that's referring to a testing request under 321J6. A test shall not be given. That's, again, a passive voice reference to who is giving the test. It's the law enforcement officer who is just, without a warrant, asked you to submit to a warrantless specimen withdrawal. And then it proceeds to talk about that the officer has to, in a certification, explain that the conditions present in 321J6 applied. So to come back to your question, which is why can't we do that reading here, it's because we're not in the implied consent regime at all at this point. The officer has gone and obtained a warrant through Chapter 808's procedures and is executing that warrant consistent with the judge's direction to do so. I would say also that our history is, in recent memory, increasingly, to respond to some of the district court's statutory interpretation, warrants can obtain bodily specimens. Just last term, this court in Burns noted that notwithstanding the initial warrantless straw search, a subsequent search pursuant to a warrant was allowed a buccal swab to obtain the defendant's DNA. We routinely have district courts correctly issuing these warrants because what your bodily autonomy and your privacy rights are protected by the Fourth Amendment and Article 1, Section 8. A warrant satisfies that constitutional right and allows the officer to collect the specimen, if it is breath, DNA, urine, etc.
Hitchens was wrongly decided under your argument here.
I believe Hitchens was wrongly decided, but we have been able to comply with Hitchens' directives. Don't ask for permission and then say, well, you didn't give me permission, I'll go and warrant. Here, after Mr. Laub did not comply with FSTs, the officer just applied for a warrant. He didn't try to invoke implied consent first. So in this case, we have followed the straight and narrow path that avoids the briar patch that Hitchens presents, and we've vindicated his rights of bodily autonomy. That's a fair question. The deputy at the hearing, if I remember correctly, thought that he was being detained for purposes of the warrant application and test. I think that's consistent with Iowa Code Chapter 808.7, but of course, if we were to get into this, this court would apply the countryman factors and determine for itself. I think that this is a fair detention for the purposes of preparing and executing the warrant.
Invoke implied consent until there was an arrest determination, right, under the statute. So
Sorry, I didn't mean to cut you off, Your Honor.
a complicating factor, I think, which cuts in the state's favor, is that the officer can't immediately go to implied consent until the statutory criteria are satisfied.
Say that under 321J6, arrest for OWI is one of the reasonable grounds that the officer can rely upon. Another would be, for example, if the driver is giving indicia of being under the influence, having driven, and fails to blow a PBT or a PBD blows. There are 6, I believe, stated criteria, and arrest is one of them.
I think the officer thought this was a detention. And I don't think he said, I'm arresting you until after he had gotten the warrant. So if that's right, and I'm not saying it is, maybe he was arrested before, but if that's right, he couldn't have even invoked implied consent at that point because he wasn't arrested.
Disagree with that, Your Honor, and we don't have to stay long on this topic because it's not material to the question. The question we're asking about today is, did the district court err in suppressing this evidence? But again, I don't think an arrest is a prerequisite for invoking implied consent. It's one of the conditions that an officer can rely upon. It's not the exclusive one. Some of our
What was taken, I mean, typically, I've seen it before when the cops miss the 2 hours for whatever reason, traffic fatality, even the serious one. No, let's not say fatality. Let's say they miss the 2 hours for whatever reason. They know they're going to lose their administrative, right? So they're not going to be able to punch their ticket for that. But they still go ahead and then get the warrant. In this situation, the warrant happened before and actually instead of. And so as far as the facts of this case, help me understand. I kind of smell a rat. That's my point.
disagree, Your Honor. This court's holdings in the former Katy court suggested in Pettyjohn that we were on a road to requiring warrants in every OWI case, notwithstanding statements to the contrary. Now, this court has walked back from the statement, but it seems unfair to me to suggest that the state is doing something nefarious by seeking approval to search.
Does it say that this is for administrative purposes only, and if you want to give up on the driver's license thing, go knock yourselves out? It doesn't say that anywhere, does it?
Also doesn't say that this is the exclusive means of investigation, and in fact says in 2 places that we want to encourage the admission of evidence.
Nowhere in this code section that says this is administrative only.
Agreement on that point. And I would also say that the idea of us going and getting warrants is completely consistent with the alternative means proposed in 321J 15 and 18. This is a statute that was created to create a legislative warrant exception to help remove people who are dangerous from our roadways. To push back on once more on your idea that there's a rat here, this is a statute that has increasing penalties for each conviction, and the state might think that getting a warrant to get its evidence and ensure a conviction is more important to get, one, that conviction, and two, that subsequent sanctions for those who repeatedly drive dangerous are imposed.
What does 321J.7 do now for unconscious people, right? Like, but what's the point of having that statute if you can just go get a warrant?
Sometimes we might not be able to, and we will need 321J7 to withdraw samples from unconscious and potentially dead individuals. It's a fallback position. It's a warrant exception that we can rely on if we wish to, but we need not. And the law doesn't require the state to take the most narrow course in its investigation. We are permitted discretion, which is part of the reason that I'm troubled by the court's equal protection and due process analysis in this case.
The defendant's argument that Oakley, Frescone, and I guess now it's Dubry, that the language is broad, but the holding might be more limited in that those cases really only address search warrants of specimens already obtained, and they really don't allow for warrants to compel the production of a specimen, if you understand. Yeah.
Just to tease a couple of them out, Oakley certainly was about a specimen that had been previously removed, so was Raines. Frescone, if I remember correctly, was about a warrant that authorized the withdrawal of the specimen from the person. The same was at issue in Dubry, although on the Article 1, Section 9 due process clause rather than search. But the point remains the same, which is that Frescone and Dubry absolutely built on what Oakley acknowledged, which is that we have no statement in 321J that is the exclusive means of investigation. And worse for that argument, there are two independent clauses that say that we should admit all evidence, and we have legislative findings.
Case law it's not as consistent as I thought it was when I looked into this area myself. That we've said at times that if you're trying to get a sample from the individual, that you have to go the 321J implied consent right.
That I can find that statement is in two places specifically, and both are dicta. The first is Stanford, which Raines built off of in making its announcement. But in Stanford, the defendant had consented to providing a sample, meaning that the court's exegesis on the idea that 321J is the exclusive remedy wasn't at issue in the case. Raines, admittedly, we did obtain a warrant to go and get it's either medical records, that might be Demeray, or again, the sample that was withdrawn for medical treatment. But again, it's dicta building on dicta. It is certainly, no case has specifically held that a warrant is not permitted to obtain this sort of evidence. And again, I don't think we should be reading in that sort of prohibition into a statute that doesn't.
Policy standpoint, we have two things that have happened in the law since we adopted implied consent. One is the one you've discussed already, which is this electronic warrants. You can get these instantaneous, push button warrants. The other is that we now have this ubiquitous body cam, dash cam. So even without a warrant, there's the ability to go back after the fact and evaluate what was really going on prior to the invocation of all the steps leading up to the invocation of implied consent in the administration of the test. Wouldn't it be fair to say that in light of all that, the implied consent regime really provides more protection because they can file a motion to suppress, they can get that neutral judicial advocate after the fact to evaluate what happened. Whereas if you get a warrant, there's this presumption of validity. It's very hard to overturn a warrant after the fact. If you're the defendant, you're better off now with implied consent.
Why you might imagine I'm surprised to be standing here at the podium right now. I mean, for years, the defense bar was suggesting that warrants were the exclusive means to go and obtain this evidence, and now we have done so, and now implied consent must now be the exclusive means. I'm going to disagree with you for a short moment, which is to say that I think we're putting horse before cart here, which is what does our statute say? And to the idea that it grants additional rights, that is because the legislature has to some degree, allowed the state more rights to detain you and test you based on your implied consent. It makes a great deal of sense why the legislature might caution that creation by saying, but you can still refuse. Those interests are not served when a warrant is approved based on probable cause.
Question that Justice McDermott asked about why the unconscious person, that one is also a path, so there could be driver's license revocation, wouldn't it be? So that does make that a little different. So, okay.
We're not talking today about revocation. We're simply talking about whether or not it is proper to suppress evidence obtained pursuant to a warrant. We can address questions of revocation in another day, in another case.
Revocation is as a way of illustrating that if you don't do these things that are in the code, that affects revocation. And I don't think the state is arguing if we get a warrant outside of this, this isn't about revocation at all. So in a sense, I think there is a purpose for 321J's testing, the implied consent, but I think of it as purely administrative. Would you?
Nature, but part and parcel of that, when we talk about the admissibility of refusal evidence at trial, that returns us in part to the criminal realm. But I agree with you. I mean, revocation is a part of what the legislature was attempting to accomplish when it created a warrant exception. Here, the state obtained a warrant, and the results should not have been suppressed. Thank you.
Thank you, counsel. May it please the court. For roughly 60 years, we've had a relatively well-oiled machine that has been carefully balanced by the legislature to give the state investigative tools to charge people, to prosecute people, specifically for operating while intoxicated cases. We also have in that regimen the ability to suspend their driver's license. That is what the legislature was concerned with, getting people off the roads. For 60 years, the motorists have come to expect that in exchange for using the roads, they will be subjected to this statutory process. Now the state wants to pull the rug out from underneath those motorists and do something that has not been bargained for, that has not been exchanged between the state and defendants. And when you do that, there's a problem. There's several problems. One of those problems is that you take away an individual's right to exercise the legislative statutory right to refuse to consent to testing. And the state has done that without any adherence to the fact that there are administrative consequences to a person's driver's license that the legislature was concerned about. They've done it without recognizing that the legislature crafted the implied consent statutes in an effort to avoid confrontations with police officers and those people suspected of operating while intoxicated. And they did it.
Asked us to overrule Oakley, Frescone. I assume the argument extends to Duber. I'm not sure how we pronounce this one. Is that necessary to find in your client's favor?
No, it isn't. And as the brief points out, there's a statutory component to this argument, and there's a constitutional component to this argument. Oakley, Demarais, Frescone, they did not address any of the constitutional implications. So I don't think those cases necessarily have to be overruled to uphold the district court's ruling and do what I'm asking this court to do.
More to me. I'm not sure that I'm following you. I thought Oakley and Frescone and now Dubry pretty clearly state that the state can obtain a warrant or invoke implied consent.
None of those cases, Your Honor, were decided on equal protection grounds, and that's a constitutional issue in this case. That's my point, is that you can decide this case on that specific constitutional issue without having to go in and overrule those cases as they relied upon the statutory.
Let me ask it this way then. Setting aside the due process and equal protection arguments, to interpret the statute the way that you think it should be interpreted, do we have to overrule those cases?
I don't think You necessarily have to overrule Oakley or Demaray. Those cases, as was previously discussed, are cases that authorize the collection of evidence that was voluntarily relinquished by a criminal defendant. So I don't think you necessarily have to do that. You can limit those cases to their holding. Frescoln, yes, because Frescoln, the backbone of Frescoln, are those two cases. And Frescoln spearheaded off of those cases by giving officers the authority that those cases did not specifically authorize. So yes, I do think you would have to overrule Frescoln on the statutory argument. Demaray and Oakley, not necessarily so. So as you look through the history of the implied consent statutes and what they were designed to do and the protections that...
Interested in the text? I mean, where is the language that you hang your hat on that says you can't go get a warrant instead of going through the implied consent process? What language, you know, if you were going to pull out a piece of the statute, you kind of weave a mosaic in your brief, but I'm interested in, you know, your go-to citation.
The implied consent statutes. So I would number one, point you to the enactment language of 321J itself. And it said, the legislature specifically said that for all violations, this chapter applies. And I don't know how we ignore that. So that's number one. Number two.
Available for all violations. I mean, that seems to me ambiguous.
Say for all violations after a certain date.
It did say after a certain date, but it still says for any violation. So to me, that is the legislature directing that chapter applies for any violation.
I mean, it doesn't say you couldn't also go, you know, go the old way either, right?
I don't have that specific language in front of me. I believe it says this chapter applies to any judicial or administrative action which arises due to a violation. So to me, that language is pretty clear. 1986, I believe, Your Honor. Then I would point you to the specific language of 321J.6, and that says any person operating a motor vehicle in this state, subject to you know, the implied consent conditions, is deemed to have given consent. So that in and of itself means any person operating a motor vehicle in the state. And then it says any withdrawal of a specimen under 321J6 shall be at the direction of the written request of a police officer. We know...
It doesn't say specimen, it says if a person refuses to submit to the chemical testing.
I think it's under subsection 321J6, subsection 1. It says the withdrawal of the substances shall be made at the written request of the peace officer. So the word shall, we know from our statutory definitions and prior case law, is a mandatory obligation. So to answer your question, Justice Manfield, I think that those statutes provide that authority. And then you look at 321J.9, which also talks about the right to refuse and that no test shall be given. I also think it's instructive to look at what our legislature did post-Hitchens.
And real quick before you get back to that. 321J6 has certain triggers for the officer invoking implied consent, correct?
I missed that first part.
6 has certain triggers before an officer can even ask for implied consent. Is that right?
Necessary conditions, correct? Yes.
Reasonable grounds to believe the person was operating in violation. And then it goes A through G. The only one that's potentially applicable here is A.
Choosing.
I understand that. So, but if B through G don't apply, the officer could only invoke implied consent if there was an arrest.
Yeah, I guess I'm not sure what A is off the top of my head, but
Lawfully placed a person under arrest for violation of section 321J2. All the rest relate to requesting or refusing the PBT on the road. So, I mean, your argument that the officer has to immediately go to implied consent seems contrary to the statute, which says the officer can't even invoke the statute until one of these criteria are met.
That statute gives an investigative procedure that should be followed in these cases, and there's no reason that the officer couldn't have asked for a preliminary breath test in this case. There's, you also,
But these triggers, you're saying now impose a duty to do them. I mean, this was supposed to limit the officer's ability to invoke implied consent. And it seems to me the way you're reading them is now the officer has to go through A through G and at least meet one of those as an affirmative obligation. It seems like that turns the entire statute on its head to me.
what the statute requires, and I think when you look at the history and the cases interpreting that statute, the reason for that is to avoid indiscriminate testing and harassment, to ensure the accuracy of the test, and to eliminate any confrontation between officers and individuals that have been arrested. So I do, yes, certainly.
The section. It's another requirement before you even get to that laundry list, right? There's no implied consent until a person who operates a motor vehicle in the state under circumstances which give reasonable grounds to believe that the person's been operating in violation, right? That's sort of a prerequisite before we even get started, right? Okay. Could police officers go and get warrants to obtain evidence that would show reasonable grounds to believe that there'd been operation? For example, if they got into a cell phone to find out, if maybe they'd been texting about their drinking and driving. That's just one example, but could they do that?
I think so, and that situation is specifically differentiated here because we're not talking about the extraction of something from somebody. So yes, I think that there are certain circumstances, and I guess I'm trying to conceptualize where that fits into the argument, but I do think that if you're going to try to get a search warrant for other evidence, and by other evidence, that's what 321J18 is titled. And I think the intent of that is something other than a bodily specimen compelled at the direction of the police officer.
Follow up on that a little bit then, is the reasonable grounds that would allow an officer to, say, ask for a PBT a lesser standard than the probable cause that would be required to go get a warrant under 808?
Very good question, Your Honor. And there's at least one case that I know of, and the name escapes me right now, one case that has kind of discussed the difference between reasonable grounds, as used in the statute, and probable cause. I think for the most part, they've been meshed into one, okay?
Breach probable cause before you can even ask for a PBT?
Under 321J.5, I think there's even just a little bit different language that directs and authorizes the administration of a PBT. I think it's a bit...
Reasonable grounds to believe.
I haven't looked at that statute for a while, but I think it's one of the same, yes.
So your opposing counsel made a comment about, this is kind of ironic. He didn't say this, but I'm saying this. The data master and implied consent has been litigated for years. So is it possible that the state's just saying, you know what, we're willing to walk away from the administrative aspects of it, and we're going straight to a warrant? And it does seem like a lot of defense arguments have been, get a warrant, get a warrant, get a warrant. There's even mats for people to walk into a house that say, get a warrant. And that's what they did. So would you address that as to why that's wrong? If I'm not persuaded that it's in the statute that allows you.
It's wrong because there has been a legislative right to refuse a right to refuse a request by a police officer to submit to chemical testing if they're suspected of drunk driving.
To administrative stuff. Isn't that what that is for? If a cop doesn't follow that protocol, they cannot yank the license.
Correct, but in State versus Hitchens, they also said you can't go get a warrant for criminal purposes to compel a sample. So it's not just purely administrative. There also are restrictions on the ability to get the evidence in a criminal context as well.
once the informed consent process had begun, right? So if you don't even go to Justice McDonald's point about 321J6, if you don't get to those prerequisites for instituting informed consent, is that a distinguishing factor from Hitchens?
Yeah, I mean, in Hitchens, yes, implied consent was invoked first. The problem here is, Your Honor, if you're arrested for OWI, let's say not arrested, you're taken in for testing on OWI. I'm taken in for testing on OWI, and Justice Manfield is the officer who's investigating us. You very well may go down the administrative 321J implied consent path because you're female. I may go down the warrant because I'm a male. So you have a right to refuse based on his unilateral decision. I do not. You have different consequences than I do. They are compelling a sample out of me. They cannot compel a sample out of you. That's a problem.
Methods are lawful. Why shouldn't the officer have discretion to use one investigative procedure versus another, depending on the facts and circumstances of the case? So if you're outside Boone County, which doesn't, maybe a county that's not using the electronic search warrant pilot program, the officer may have to get implied consent because they can't find a magistrate, it's too difficult, maybe there's other circumstances. Here, they have the technology available. They make a discretionary choice between two lawful ways of investigating a crime. Why is that unconstitutional?
Because it's a statutory right that's being usurped and it violates equal protection. That's why it's unlawful.
It's only unlawful assuming that the statutory right exists. If we conclude that the statute doesn't give the right, then the officer's choosing between two lawful means of investigation. Isn't that right?
Because the 321J has specifically said that when you're going to withdraw a sample from a suspected driver, that because of the enactment language and the language in 321J6, that's the route that you are supposed to go.
I don't want to belabor this, but Fresco, you just told us Fresco and Duber say that's not right. I mean, you're asking us to overrule two decisions that say the opposite. And it seems like your constitutional argument hinges on, first, the statutory one.
And maybe I'm not fully grasping your question. I apologize if that's the case. I see I'm up, but I'll try to answer your question if the court will allow me to do so. Okay. So as I see it, I'm not sure how Dubre really fits into this equation, because to me, this is, that was the constitutional provisions were completely different. We're talking about, the right to withhold your ability to talk to police and confrontation, those kinds of things. What I'm talking about is equal protection, and Dubre didn't address equal protection at all, nor did Fresco. In fact, it was raised, but specifically not addressed. So I'm not sure that answers your question, but I'm also not sure I entirely grasp it, so I apologize. I did my best. Thank you, Your Honor.
Mr. Howe.
We shouldn't read a statute to create something that the legislature didn't intend, which is a criminal defendant that has more rights than any other defendant in the state to refuse a lawful investigation. When the legislature created implied consent and its administrative regime, as well as its means to conduct a warrantless search, it sensibly gave defendants a right to refuse it because it is an implied consent. And by the time we're asking for a chemical test sample, that consent is either real or not. And if the defendant declines to participate, then the administrative regime kicks in and the license is revoked.
Let's say that I don't want the government to have my blood, okay? And I decide that I want to drive, and I want to know under what circumstances does my driving permit the government to get my blood. I go to 321J, and I see that I have a right not to give my blood if I say no, unless I get in an accident or I'm unconscious while driving, right? I mean, isn't that sort of the deal that 321J sets up?
I think that what it does is it says, the state, you may go and get this evidence unless the person refuses a blood test, at which point, unless certain exceptions apply, then the state may go get it. Can we imagine another crime in which a defendant can refuse a lawful court order? No, it's contempt, which is what 321J10.5 says. This exchange of the right to the roadway in exchange for the implied consent makes sense when we're talking about consent. It does not make sense when we're talking about a lawful order from a court to permit an officer to obtain evidence. I'd like to briefly talk about the word shall. I think it does some amount of work in this case, but not in the way that my opponent suggests. Shalls mean a great many things throughout the Iowa Code. Sometimes they are mandatory, sometimes they are directory, sometimes they are permissive. As former Justice Scalia and Garner say in Section 11 of their treatise on, unless the legislature clearly indicates a shall for the government is a permissive shall. So in this instance, under 321J6, when the foregoing criterion are satisfied and the officer is invoking implied consent procedures, then the officer shall comply. Makes perfect sense. But what it does not say is that the officer must. It does not say that the officer cannot go and get a warrant. And we shouldn't read additional provisions into this chapter.
About statutory interpretation, would you agree section or chapter 321J is a comprehensive scheme?
With regards to OWI, give me a little more detail, Your Honor, please.
Why?
Is certainly the one chapter that contains both the crime, the means for investigation, and administrative sanctions.
We've got other cases where we've adjudicated whether a particular statute is the exclusive means to pursue a remedy. And we've held several times that the statute does not have to say this is the exclusive remedy. But we look at criteria including, is this a comprehensive scheme where we figure the legislature has done the balancing? And it seems to me you've got, persuade me that we should allow officers to sidestep this very detailed, balanced, comprehensive scheme.
Statute presupposes that the officer can. 321J 15 and 18 both say that we are admitting evidence of this, and 321J 23 tells us why. Impaired driving in this state has lethal consequences that we are concerned about, and we have as the United States Supreme Court said, paramount interest in preventing it and punishing it. We should not punish officers who comply with people's and give full vindication to their constitutional rights by suppressing evidence. It doesn't make sense under due process. We don't suppress under equal protection violations, and we don't go looking for conflicts in statutes, even comprehensive ones, where they can coexist. And we have given you a completely plausible reason under our interpretation why both exist. Sometimes it might not be possible to go and get that warrant, and we will need implied consent, and we should not foreclose it now.
The specific controls over the general. We have a statute that gives motorists a right to refuse a blood sample or breath test or any of those. And yet, under your interpretation, that why shouldn't that control the situation of a motorist suspected of drunk driving?
That, Your Honor. One, we don't go looking for conflicts where they don't exist. Specific controls only when there's an irreconcilable conflict. I believe that's section 27 or 28 of
Statute, the OWI statute says you have a right to refuse.
implied consent is invoked, and when we obtain a warrant independent of that sequence, you don't have a right to refuse, just as you don't have a right to refuse a warrant generally. Now, there could be, and forgive me for going over time, I will be brief. There is an imaginable instance in which the state obtains a warrant and the means used to execute that warrant are unreasonable. But we're not there today. If you reviewed the video in this instance, and part of this response to why the implied consent regime is concerned about officer interaction, when you have something from a judge that says you need to comply with this, and Mr. Laub was told that, he instantly complied. I think that his constitutional interests were served, and I think that the district court in this case turned implied consent into a shield when it was meant to be a sword for the state with some reasonable provisions for the independent defendant drivers. For the foregoing reasons, the state would ask that you reverse and remand with directions for this case to continue. Thank you.
State versus Laub is hereby submitted, and court is adjourned for the day.